Module 10. Appeals. Introduction. If the defendant is found guilty, there may be grounds for an appeal, challenging errors or misconduct that occurred during the trial. Remember, the specific defenses available and their requirements can vary based on the jurisdiction and the nature of the crime. Criminal defense is a complex field, and individuals accused of a crime should seek the advice and representation of an experienced criminal defense attorney to ensure their rights are protected and they receive a fair trial. Appeals are legal proceedings in which a party who is dissatisfied with the outcome of a trial seeks to have a higher court review and potentially overturn the lower court's decision. The party initiating the appeal is known as the appellant or the petitioner, while the opposing party is called the appellee or the respondent. The purpose of the appeal is to challenge errors made during the trial process or to raise legal issues that could have affected the fairness or legality of the original judgment. Key points about the appeals process include: grounds for appeal. Appeals are generally based on specific legal grounds, such as errors in the application of the law, erroneous jury instructions, improper admission or exclusion of evidence, misconduct by the opposing party or the judge, or violations of constitutional rights. Notice of appeal. To initiate an appeal, the appellant must file a notice of appeal with the appropriate appellate court within a specified time frame after the trial court's judgment is entered. The rules and time limits for filing appeals vary by jurisdiction and the type of case. Record on appeal. The appellant's attorney prepares a record on appeal, which includes all relevant documents, transcripts of court proceedings, exhibits, and other materials from the trial. This record forms the basis for the appellate court's review. Briefs. Both parties submit written legal arguments called briefs, outlining their positions and addressing the legal issues raised in the appeal. The appellant's opening brief presents arguments for reversing or modifying the trial court's decision, while the appellee's responding brief defends the trial court's judgment. Oral arguments. In some appellate courts, the parties may also present oral arguments before the appellate panel or judges. This allows the attorneys to further explain their positions and answer questions posed by the judges. Appellate decision. The appellate court reviews the trial court's proceedings and the parties' arguments. The court may affirm the lower court's decision, reverse it, modify it, or remand the case back to the trial court for further proceedings. Standard of review. The appellate court applies a standard of review to evaluate the trial court's decisions. The standard can vary depending on the legal issue being appealed. Common standards include de novo review, entirely new review, abuse of discretion, and clear error. Finality of appellate decision. The appellate court's decision is typically final, and the parties must abide by it. However, in some cases, parties may seek further review from a higher court, such as a state Supreme Court or the U.S. Supreme Court, but such reviews are generally granted only in limited circumstances. Appeals are complex legal proceedings that require specialized knowledge and expertise. If a party is considering filing an appeal or defending against one, it is crucial to seek the assistance of an experienced appellate attorney who can navigate the appellate process and present a compelling legal argument on their behalf. Assessment methods. Quizzes and examinations. Research papers or case studies. Class discussions and participation. Group projects and presentations. Practical exercises, such as crime scene simulations or mock trials. Thank you.